An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Governmental Purpose to Advance Religion, McCreary County versus ACLU of Kentucky, 2005, Van Orden versus Perry, 2005. The First Amendment begins, Congress shall make no law respecting an establishment of religion. This provision is known as the Establishment Clause. At the time the First Amendment was ratified, several states had established or official churches. Some of these states retained their official churches until the mid-19th century. Yale law professor Akhil Amar contends that the Establishment Clause performed two functions. First, it prohibited Congress from establishing a national church. That is, Congress shall make no law respecting a national establishment of religion. Second, it prevented Congress from interfering with state churches. That is, Congress shall make no law respecting a state establishment of religion. Under Amar's view, the Establishment Clause imposed no limitations on states. Rather, it serves as a structural limit on federal power. In contrast, the Free Exercise Clause protects individual rights. Study guide. If Amar is correct, should the Establishment Clause be considered incorporated by the 14th Amendment, or does it resist incorporation like the 10th Amendment? The Supreme Court's recent Establishment Clause jurisprudence rejects this founding-era understanding. Instead, the Court has looked to a much-discussed letter by Thomas Jefferson. In 1802, President Jefferson wrote to the Danbury Baptist Association in Connecticut and included the now famous phrase, a quote, wall of separation between church and state. To effectuate the separation of church and state, the Supreme Court has identified three kinds of government acts that constitute an establishment of religion. First, in Lemon v. Kurtzman, the court prohibited state entanglement with religion. Second, in Marsh v. Chambers, the court prohibited state endorsement of religion. Third, the court has prohibited a state's purpose to advance religion. This video will focus on this final test with two related cases, McCreary County v. ACLU and Van Orden v. Perry. Both cases involve public displays of the Ten Commandments, one in Kentucky and the other in Texas. Both cases were decided on the same day in 2005 by a 5-4 vote. However, the Kentucky display was declared unconstitutional while the Texas display was upheld. And Justice Breyer was in the majority in both cases. How did this split happen? Let's start with the Kentucky case. County officials erected 3 separate displays of the Ten Commandments in their courthouse. Justice Souter stated the facts. The first display
consisted of a large gold-framed copy of the Ten Commandments that was hung in 1999 in a busy hallway.
The American Civil Liberties Union, or ACLU, challenged the constitutionality of the first display. In response, the county erected a second iteration of the display. It added
smaller-sized patriotic and legal documents that highlighted religious references
around the Ten Commandments frame. The district court
found that both the first and the second displays lacked any secular purpose, and that the county's object was instead to advance religion in violation of the Constitution.
Secular, as opposed to sectarian, refers to a non-religious purpose. After this ruling, the county erected a third display.
This one was entitled The Foundations of American Law and Government, and it comprised an expanded text of the commandments, surrounded by equal-sized copies of such documents as the Bill of Rights, a picture of Lady Justice, and the lyrics of the Star-Spangled Banner. The commandments now had an explanatory note next to them stating that they profoundly influenced the formation of our country.
The lower courts found that the third display was unconstitutional. The case was then appealed to the Supreme Court.
The primary questions this case presents are, first, the extent to which governmental purpose is relevant in enforcing the Establishment Clause, and secondly, whether past official action can be relevant in evaluating current actions.
The Court explained that in Establishment Clause cases, determining the government's
purpose is critical because it directly relates to a central Establishment Clause principle, neutrality, the idea that the government may not discriminate among religions. We thus reaffirm today that government action predominantly intended to advance religion is not permitted under the Establishment Clause.
Justice Souter focused on the history of the three displays. The first display, which consisted of the Ten Commandments,
in isolation, leads to the inescapable conclusion that the counties intended to put out a religious message. The second display only amplified this religious message and could leave no doubt that the counties intended to make a religious statement. In evaluating the third display, we have to consider the two displays that immediately preceded it.
Justice Souter concluded that
the counties had not shown a new secular educational purpose
to justify inclusion of the Ten Commandments display. Critically, the Court did not hold that the government would be forever bound or tainted by past purposes.
We do not hold that past unconstitutional purposes forever taint future government action. Instead, we acknowledge only that stated purposes must be creditable before they will be credited.
Study guide. Should courts consider political events that come before an official state action? Should judges consider, for example, statements made on the campaign trail or a politician's tweets? Justice Souter wrote that, although a legislature's stated reasons will generally get deference, the secular purpose required has to be genuine, not a sham, and not merely secondary to a religious objective. McCreary County argued that the display was intended to educate people about the role the Ten Commandments played in developing the rule of law.
There is no freedom without the law.
However, the Court found this purpose to be, quote, an apparent sham. In other words, the display was designed to promote a specific religious text. The county's justification was a pretext. Therefore, the Kentucky display violated the Establishment Clause. Justice Scalia wrote a dissent on behalf of Chief Justice Rehnquist and Justice Thomas. Justice Kennedy joined in part. Justice Scalia began,
"Today's opinion ratchets up this court's hostility to religion."
Justice Scalia recounted many instances in which the founding generation acknowledged the role of religion in society.
George Washington added to the form of presidential oath prescribed by Article 2 of the Constitution the concluding words, "So help me God." The Supreme Court under John Marshall opened its sessions with the prayer, "God save the United States and this honorable court."
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh, yea, oh, yea, oh, yea. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
The first Congress instituted the practice of beginning its legislative sessions with a prayer. The same week that Congress submitted the Establishment Clause as part of the Bill of Rights for ratification by the states, it enacted legislation providing for paid chaplains in the House and Senate.
Let us pray. Gracious Father, our shield and defense, we look to you in these challenging times.
President Washington offered the first Thanksgiving proclamation on behalf of the American people, quote, "to the service of that great and glorious being who is the beneficent author of all the good that is, that was, or that will be."
In light of this history, Justice Scalia could not understand how the Court could claim that
the First Amendment mandates governmental neutrality between religion and non-religion. and that, quote, manifesting a purpose to favor adherence to religion generally is unconstitutional. Who says so? Surely not the words of the Constitution. Surely not the history and traditions that reflect our society's constant understanding of those words.
The dissenters would have upheld the constitutionality of the Kentucky display. The facts in Van Orden versus Perry were different. On the grounds of the Texas State Capitol is a 6-foot-high stone monument inscribed with the Ten Commandments and other religious symbols. The Fraternal Order of Eagles gifted it to the state in 1961. Then Attorney General and future Governor Greg Abbott defended the monument.
The Texas monument should not be torn down from its historical place for 3 reasons. First, the Ten Commandments is an historically recognized symbol of law. Second, this monument is one of the smallest of the 17 monuments on the Capitol grounds. Like most of the other monuments, was a gift to the state of Texas and is clearly recognized as such on the monument itself. And third, this monument has stood for more than 40 years without controversy on a national historic landmark.
Law professor Erwin Chemerinsky argued that the monument was unconstitutional.
When the government puts sacred and solemn text taken directly from the Bible at the core of its state government, it has to then do something to convey the message that it's not there for religious purposes, that it's there for secular purposes.
By a 5-4 vote, the court held that the
display of this monument with both religious and secular significance does not violate the Establishment Clause.
At this point, Justice Rehnquist was quite ill from the cancer that would take his life some 2 months later. Study guide. Justice Breyer joined the majority opinion in both McCreary County and in Van Orden. Can you reconcile his votes? Justice Breyer found this a borderline case. However, he concluded that the Texas display communicates both a religious and a secular message. Therefore, it was constitutional. Justice Souter dissented. He wrote that, quote, "This display of an obviously religious text cannot be squared with neutrality." Justice Souter noted that a reasonable observer would, quote, "need no training in religious doctrine to realize the religious nature of the display." Justice Souter acknowledged that there is a relief of Moses and the Ten Commandments in the Supreme Court chamber. However, he found this local display quite different.
Moses and the commandments are displayed in this very courtroom up on the South Frieze. But Moses stands there in the company of other lawgivers, both great and secular, demonstrating that the display is about lawgivers, not about religion, and was not the product of some religious objective.